This is episode 14 or 15?
I think it's 14.
Okay. Hi, everybody. Welcome to Immigration Talk, episode 14, with myself, John Khosravi, immigration lawyer, my wonderful associate attorney, Anna Sergeeva. How are you doing, Anya?
I'm okay, John. Everything is fine. Spring is coming. The mood is good. H-1B season is almost here, and we're going to talk about it today.
Yeah, we're going to go into detail like we have for the previous month about different aspects of H-1B, in particular the H-4 category, that the dependents of an H-1B holder. It's very important. You got to know what's going on, and there's a lot of nuances there that we'll dive into to give you an overview. But before that, we want to talk about some news about asylum cases, in particular them adjusting what they consider spouse or asylum cases. Our office is not an active asylum case firm. We don't handle asylum claims, but sometimes someone, for example, has an asylum approved in the United States, and then they need to bring their spouses overseas here. We do the follow-up stuff that deals with consular processing. So it's an important thing to know and to do, as well as if they're adjusting in the United States potentially, then this might be needed. If you haven't already, if you're watching the show, like and subscribe so you get a bunch more content like this. We have hundreds of clips and a lot of information that's cutting news and cutting edge stuff about what's going on in immigration practice. And please follow us all over on Instagram, on Facebook, on TikTok, Immigration Lawyer John, very active over there. But having said that, let's get it started. So, Anya, yeah, we saw the news, USCIS and their refugee division announced that the Refugee Asylum International Operations announced that they're going to allow camp marriages. This is kind of like informal kind of marriages that happen, because when you're an asylee and you're overseas, you're a refugee, you can't always go to the government and say, I want to get married. You might be a group that's not permitted to get married. It might be a group that's under stress, and they might be chasing you around the country, try to kill you. So it used to be that they're more flexible about this. They had stopped that, and gotten strict about accepting these informal marriages. But now they're back to opening up to, again, particularly this I-730 petition, when you're, you might be in the U.S. and you're asylee, that informal camp marriage that occurred overseas is still possible. So that was an interesting thing to help a lot of people who are stuck in this situation all over the world right now that are dealing with this.
Right, and it's interesting to look at it from other point of view. Specifically I-130 petition. So why it's gonna work for asylees or refugees petition specifically form I-730, right? And it's not gonna work for the form I-130.
Yeah, the I-130 being the marriage petition. If you're a green card or citizen, you want to bring a spouse. This does not. I'm glad you mentioned this so people don't confuse it. This ruling is just for, this policy decision is just for asylum cases, not for marriage cases. They're strict on that. You need to be by the book and have it registered as appropriate in the jurisdiction that you're married in.
Right, and what we see often in the context of I-130 spousal marriage petition, during pandemic, a lot of people they were not able to get married like in person, and they were getting married online. Mm-hmm. And it's a separate, very interesting topic to talk about it too. Just a couple of notes about that. First thing. I think Utah and Montana, at least two of these states, U.S. states, they allow online marriages. What we've seen in our practice.
Yeah.
And probably there should be some more, but I'm not sure about this. But this two for sure.
Yeah.
And the important thing about online marriage is that it has to be consummated after the marriage occurred. So, for example, if you were dating your future spouse, it will not count, like you being with your spouse in actual physical location after the marriage was entered into. That's what is needed for USCIS, and they will accept it with these terms.
Yeah, we do that having photos, but also sometimes we even say get a newspaper, hold together that has a date, so you could show that on this date after the marriage you're together. Flight records to fly to see each other, hotel records, all this kind of stuff. They're usually pretty accommodating by accepting it, but that consummation is really key. Now, an interesting thing you brought up regarding this memo that came from Department of Homeland Security is how it was signed. And it's inconsistent with how they allow us to do stuff as petitioners, as lawyers, and all that kind of stuff. But what this revised guidance on informal camp marriages issued by the acting associate director of Refugee Asylum International Operations is signed a little bit differently than which is legal. So I'm not sure if this memo eventually they're going to sue on it and say it's incomplete. But could you talk about that?
Yes, it's just an interesting point that I noticed when going through this document. It was signed like digitally,
Mhm.
and the interesting thing that USCIS does not allow us attorneys or petitioners, applicants to sign their petitions, any paperwork that goes to USCIS digitally. It has to be signed handwritten by ink, black ink preferably, right? They allow scanned signatures, but they
Mhm.
don't allow signature, for example, that you paint in your computer or
Yeah.
on your phone. It has to be actual handwritten wet signature.
Yeah, so they right on there is right, it's digitally signed. I mean, they really put in your face. So I'm not sure how that went by, and in fact, it's going to create a problem for this memo. But that's just it shows like there's two sets of rules, one for me and one for you. That's how it goes. That's how governments usually operate. But hopefully they make it easier because it is hard. People don't have printers sometimes overseas. Sometimes it really makes things faster. What's the difference between someone signing it and then they don't know if actually signed it. It doesn't really prove much whether it's digitally or ink signed at the end of the day.
Right, but this is current policy, and we've seen when, for example, clients come to us after they file pro se, after they file without an attorney,
Yeah.
and they can get RFE, for example, for affidavit of support from NVC saying that this was signed digitally, and we need your actual signature. So you actually need to print this form, sign it, scan it back, and send it to us.
I
And
had a
yeah, and it delays the whole process by like at least a couple months.
I had a devastating case where a guy was a student visa holder, and before graduation, he filed for optional practical training (OPT). It's a work permit that allows you to work, obviously, for a year after graduating. And he submitted it with a digitally signed signature, thinking it's okay. It took them 4 or 5 months, but they finally responded denying the case once they realized that. And by that point, the deadline for filing for work permit was gone. So he was immediately have to leave the country at that point. He couldn't even take advantage of his OPT. And his whole life, his plans, the employment he had lined up, everything got messed up because he didn't understand or know about this requirement. So you got to be very careful and just know there's a million and one different things with immigration law that could be problematic. So watch out. Now, the next thing I want to talk about is an important topic because we get a lot of context from this. It's the H-4. So just a background, when a specialized worker is approved, it's an H-1B visa to come and work in the United States. These are people usually with degrees or a lot of work experience who come in certain specialized knowledge jobs. Now, their spouse and kids could also get a companion visa. It's called the H-4. I'm not sure why they skip from H-1B being the primary and then all the way to H-4 for the secondary. There is a thing called the H-2 visa and H-3. Those are certain kind of training and temporary visas. That's probably why that happened. But the dependents are H-4s. And so they could, come to the United States, but there's a lot of back and forth. There are lawsuits about, different aspects of this visa. Could you just talk about some notes you wanted to mention about the H-4 category, Anya?
Yes, sure. Before I talk about H-4s, I just want everyone to watch our previous videos where we were talking about the H-1B preparation process. We also spoke about the H-1B cap gap. So I think a lot of people find this information interesting. So please stop
Yeah,
now and watch this video before that one because
that's
it
really
has to be.
important. There's one
Yeah.
transition from F1 to H-1B, so you're pre-planning how that's going to go and STEM and all that kind of stuff. We did thorough videos, so definitely check that out. I'm glad you brought that up.
Right. So going back to H-4. So what is H-4? H-4 is a temporary visa that is issued for dependents of H-1B visa holders, H-2A, H-2B, and H-3. So that's why the answer to your question, why it's not H-2 or something, well, that's what it is.
Yeah, exactly.
And first thing, what's important for someone to qualify for this visa, it has to be either spouse, and again, legal marriage is required. Going back to what we just talked about, it has to be valid in the jurisdiction where it was entered into.
Mhm.
So again, online marriages and all these things, they might work again if there was a consummation and
Exactly.
what we just talked about. So it has to be valid marriage, and for kids can also qualify for H-4 visa as long as they are under 21 years of age. Okay. And H-4 status is valid as long as the H-1B visa holder maintains his or her H-1B status. And as you may know, initial H-1B status can be valid for 6 years, right? And 3 years increments. And after that, it can be also extended almost indefinitely under certain provisions. For example, if H-1B visa holder have I-140 petition approved, right, or under AC-21, which is the I forgot the abbreviation. I'm so bad with abbreviations, sorry guys. So it's American Competitiveness Act in 21st century, something like that. Right? So under these provisions, H-1B visa holder can get extensions of their status as well.
And H-4 along with that. Yeah.
H-4s, they're not counted towards the H-1B visa cap. So just the primary H-1B visa holder counted towards the cap. And the number one thing probably that we encounter in our practice is that H-1B visa holders, they are not authorized to work incident to status, unlike, for example, spouses of E-visa holders, specifically E2s, right? Or L2s, which are spouses of L1 visa holders. They both are authorized to work incident to status. And recently there has been this huge litigation, and I think in fall of 2021, USCIS finally recognized that these visa categories are authorized to work incident to status, and they don't need to get their EAD. But it's only for E and Ls, but not for H-4s. H-4s still have to file for employment authorization document, and not everyone, not all H-4s qualify for that. Okay.
And the annoying thing about that whole process is it was taking a long time. That's what these lawsuits kind of are presenting as saying, why is it taking a year to get the employment authorization approved in these kind of cases? Or even if someone came to the United States, got an H-1B change of status, and H-4 for the spouse at H-4 might take a year for the change of status to go through. So they're stuck in this limbo. It was really debilitating. And so there's a lot of lawsuits and some success that's happened. But I just want to mention that quickly. Go ahead, Anya.
Yeah, it's, I mean, little by little, USA is getting towards to alleviating this H-4 status, because there are a lot of people, a lot of spouses here in the United States, and they cannot work. They cannot work, and most of them, they have college degrees, and it's so many people that are just not participating in U.S. economy directly, you know, and it just sad situation to me. Yeah, so going back to work authorization for H-4 visa holders, not everyone qualifies. Only those whose H-1B spouses visa status were extended under AC-21, or if they have I-140 petition approved, but they cannot file for green card because there is no visa available right now. So spouses of this H-1B visa holders category, they can apply for employment authorization document. Okay, and what's important here to note is that H-4s, they're not restricted by the employer, so they can work anywhere as long as they have the valid EAD card. They cannot start working unless and until they get the actual card. Okay, this is good to know too. So recently there has been like a big change to that. Previously, H-4 visa holders, they were not able to get automatic 180-day extension for their employment authorization documents. But again, because of this litigation, recent litigation, now they are. But certain conditions have to be met too for them to qualify. First is that they have to file while their previous EAD card is still valid. Okay, and the second one is that they have an expired form I-94. So if those both conditions are met, automatic extension will work in this situation.
Now, a quick note, because of all the delays that have been happening, one was the requirement that President Trump's administration started, that everyone changing status or extending status needs to do a biometrics appointment, a fingerprinting appointment. That wasn't a requirement. They did temporarily suspend that because of how much delays were happening. So for effective May 17, 2021 through May 17, 2023, so for a 2-year period, if you are doing an extension of stay or change of status to an H-4, The biometrics is not required for now. Hopefully that continues because it's such a delay filling kind of thing. But we're good on that for now if you're watching during that period.
Yeah, thank you, John. I'm glad that you mentioned that. This is very important too, because we've seen when clients come to us, they file, for example, or their other attorney of the employer files, right? And USCIS were sending back this change of status applications because of biometrics, because they included the biometrics.
Yeah,
you know,
the fee and everything. Yeah, that's
yeah.
so going to be confusing. You have to be really careful. Now, USCIS does have a webpage on USCIS.gov that calculates what the fees you're supposed to submit are. So be very careful because this is really confusing when you submit a fee, when you don't. If it's a minor child that doesn't, it does it, all this kind of stuff. And they change it so frequently. It's like a minefield of issues that could happen.
Right. So a couple more important notes about H-4 employment authorization. So only spouses qualify for employment authorization, not the kids, not children, unfortunately. But both children and spouses, they can study in the United States. And there's no need to file for change of status to F1. It might be helpful in some situations because, for example, if you want to do OPT or CPT, all right, you need to change the status to F1 first before getting this.
Yeah, what you said, so OBCP is work authorization incident to being a student and related to being a student. But let's say you have a spouse with H-1B and the H-4 wants to study. It's a good backup to have the H-4 being an F-1 student, just in case the H-1B loses their job or the company shuts down. They could then transfer and become an F-2 dependent spouse of a student visa holder. So it's a good backup to have that's ready to go in case you feel like something's not, we're working smoothly in the place of the H-1B employment. Now, as an F-2 spouse, you can't work per se, but it's better than all of a sudden be out of status and have to work fast to try to figure it all out.
Right, and it might give you a necessary time to find a new employer, for example. And again, if you already had an H-1B visa or H-1B status, right, you're not counted towards the cap, right, in certain circumstances, which is one of this, right? So it might be just a good thing to consider if you find yourself in this situation. Yes, so for very important thing too, if you are filing to change your status to H-4 in the United States, it's very important because a lot of people forget to do it, and a lot of attorneys for employers forget to do it for their because it's different issue of dual representation and other things. I'm not gonna go into that. But the problem with that is that employer files H-1B petition for the primary worker, right, and they forget to file change of status separate applications for the family. Exactly. And separate application required for to change status to H-4. It's form I-539. And if it's not filed, it's a huge problem. We've seen situations when, for example, it's called Nunc pro tunc extension were granted when they granted it after the fact, but you really don't want to do that.
Yeah, so make sure to correct an error that happened, and it's discretionary, so we want to rely on that. And kind of on that note, when the spouse does apply for change of status on the I-539, the children could come under that. They have some separate stuff they have to submit. But sometimes I've seen employers tell the client each family member has to file their own I-539, which results in a lot of extra filing fees that aren't needed.
Right. One more thing, last thing that I want to mention too, that H-1B petitions, they qualify for premium processing, unlike I-539 petitions for family members to change their status to H-1B, to H-4. And what we see is that the original H-1B, initial H-1B petition gets approved within like 15 calendar days, for example, if it's premium processing, right? And if the option is available. And H-4 change of status can be dragging for like months.
Now, there might be people who done this and they had differently. Up until about a year and a half ago, The premium processing service centers, as a matter of, I guess, discretion, had a policy of adjudicating both at the same time, and even adjudicating the work permit for the H-4, for example, if needed. This is primarily L2 context that we would do it in, and they would approve it all at the same time. But all of a sudden, overnight, without telling us, they made a switch, seeing like, change of status cases where the spouse is just, nothing's happening. And we email them and they say, oh, we don't do that anymore, just goes regular processing. So they do everything they can to make life difficult. They're trying to fix this stuff up. Hopefully they will, but be prepared for this kind of inconsistency that kind of doesn't make sense, especially because it's a family unit. But this is how it is right now.
Right. And one last thing is that H-4 visa holders, they can change their status to other visa categories. For example, as we just spoke about, to F1, sometimes even to B2. If the applicant qualifies for that. Yeah. What we see too, spouses can switch between H-1B and H-4 when, for example, one spouse reaches the six-year limit, and there is no I-140, there is no AC-21 provision that can work for them, and this is another option to kind of extend your stay in the United States when former H-4 spouse becomes primary H-1B visa holder, right, and vice versa, because this time that spouse spends in H-4 classification in the United States does not count towards the H-1B time limit.
Well, great. Thank you so much. There's a lot of information there, but H-4, we get the calls and all these different questions. There's even more stuff than this because it's a decision to make for your family, your kids, and everything. How are you going to handle it? And sometimes you make a change on the spot. So hopefully this video will give you some idea of the options available. If you're interested in learning more, email us at info@jqqlaw.com and briefly describe the immigration issue that you have so we can better understand if it's the kind of case we can help you with, or at least have a basic initial consultation about. Either Anya and I will be there to help you out. If you haven't already, like and subscribe to get more videos like this. And Anya, do you have any last word or anything like that?
No, I'm done. This time.
Yeah. Wonderful. Thank you so much. We'll catch you all next week with Immigration Talks episode 15, and just break down news and some really deep informational stuff to help you with your immigration process. Until next one, be safe. Bye-bye.
Thank you, guys. Bye-bye.
Thank you for watching this educational program. To get the latest videos, click the subscribe button and the notification bell icon. Also, help us help the immigrant community by liking this video and sharing it with your family and friends. You can also find us on other social media sites like Instagram, Facebook, TikTok, LinkedIn, and Twitter, where you find the latest updates on immigration news, policy changes, and tips. Be safe and God bless. See you soon.